Welcome. You're speaking with Attorney Bazan. Today, we will focus on what are the most common ways of obtaining a green card. There are multiple ways that you can obtain a green card, but amongst the most common ways of obtaining a green card is through family-based petitions, where a family member petitions for you. A resident can petition the immigrant, can petition their spouse or their unmarried child. A citizen, on the other hand, can petition even more people. They can petition their spouse, their married or unmarried children, their parents, and their siblings. You must be careful with these petitions. Not everybody qualifies, not all family members qualify. You have to make sure that you're not triggering a ground of inadmissibility, such as unlawful presence, fraud, misrepresentation, or criminal convictions, amongst others. So you really need to consult with an attorney because every case is different. If your family member enters the country illegally, you have to ask for an unlawful presence waiver, the provisional waiver that came about in 2013 and then was expanded in 2016. Because you have to waive the unlawful presence and the unlawful entry. How do you qualify for this waiver? Well, you have to prove extreme hardship to the U.S. citizen or resident relative, the spouse or parent. Therefore, it is important to consult with an experienced attorney while doing this waiver. You can watch our upcoming video on provisional waivers. If things don't go so well and the immigrant is abused by the U.S. citizen or resident spouse, parent, or child, they can self-petition based on the Violence Against Women's Act. They can self-petition if they have been emotionally and or physically abused. And they have to prove that they have a legitimate marriage if it's through their spouse. And ultimately, they can obtain lawful permanent residency status, commonly known as a green card. Many immigrants do not have family members that could petition for them or an employer. And so there's very few things that they can do, but if you are a victim of a crime and cooperate with the authorities, you can perhaps get an immigration status. Your spouse can derive the status, your minor children under 21 as well. And if the victim is a minor under 21, their parents can derive the status. The U visa is a lawful status. It grants you an employment authorization document. And eventually, after 3 years in that status, you can apply for lawful permanent residency status for you, your spouse, and your minor children. It waives many grounds of inadmissibility. The U visa is a great option. As you will see on the screen, there's the list of crimes that qualify for the U visa. Amongst the most common crimes that qualify for a U visa would be felonious assault, domestic violence, sexual abuse, rape. To give you a concrete example, say for instance you were assaulted on the street, you were physically hurt and they robbed you as well, but mostly just physically hurt. That would be felonious assault, for instance, and you call the police, you go to the hospital, you can probably obtain a U visa. If the person is a victim of domestic violence outside of the United States in their home countries, for instance, they can maybe apply for asylum. Now, the term asylum has been commonly known as political asylum. Many people believe it's just for political opinion, but that is not true. Asylum is based on 5 grounds. If you have been persecuted because of your political opinion or because you're a member of a social group or because of your religion, race, or nationality, you can apply for asylum within the year of coming into the United States. If you have been a victim of domestic violence in your home country, that falls into membership of a social group. Therefore, you will get asylee status. After a year of having asylum status, you can self-apply for a green card, for lawful permanent residency status.